Good morning, this is your Kelso Report for Thursday, October 18th, and I'm your host, Clark Kelso. Our first case today has the Ninth Circuit wisely deferring to the Bonneville Power Administration's decision to enter into a special contract with Alcoa. And then we turn to three California Court of Appeal decisions, the first reminding us that a person must agree to an arbitration clause in order for it to be enforceable. The second involving the broad preemptive reach of federal law regarding railroad operations, and the third recognizing an important limitation on anti-SLAPP motions. We begin with the Ninth Circuit. Government agencies sometimes do more than just regulate and monitor markets. Sometimes government entities are major market participants. When government agencies are placed into the market, one of the common questions that arises is whether they are supposed to act the same as private companies when it comes to maximizing profits. More often than not, the answer to this question is no, because public entities as market participants usually have broader public responsibilities than just profit maximization. A good example of this is the Bonneville Power Administration, a federal agency within the Department of Energy which has marketing authority over nearly all of the electric power generated by federal facilities in the Pacific Northwest. On its website, www.bpa.gov, BPA identifies its four public responsibilities as follows: high reliability, low rates consistent with sound business principles, responsible environmental stewardship, and accountability to the region. The BPA entered into a special contract to sell surplus electricity to Alcoa, obviously a major industrial buyer, at very favorable rates, making almost no profit on the deal. BPA's so-called preference customers, as well as other entities and organizations in the Pacific Northwest, filed a petition for review, requesting that the Ninth Circuit hold that the contract is unlawful because it is inconsistent with the agency's statutory mandate to act in accordance with sound business practices. In particular, the petitioners complained that BPA's decision to forego significant profits from its Alcoa contract was contrary to sound business practices of profit maximization and injured them because, absent those additional revenues, BPA was required to maintain their preference customer rates at higher levels. In reviewing BPA's contract with Alcoa, the Ninth Circuit adopted the usual standard for judicial review of administrative agency action, namely the exceedingly deferential, arbitrary, capricious, and abuse of discretion standard. The court noted that it would not second-guess BPA's policy judgments and that it would defer to BPA's reasonable interpretations of its governing statutes. In light of the deferential standard, the court easily upheld BPA's contract with Alcoa. Although offering low rates consistent with sound business principles is one of BPA's public responsibilities, it also has broader responsibilities to the region. And the Ninth Circuit was unwilling to second-guess BPA's policy judgment regarding the costs and benefits of its sale of electric power to particular customers. Now we turn to three Court of Appeal decisions, California Court of Appeal decisions. First, in the area of arbitration. As a general rule, a superior court will enter an order compelling arbitration of a dispute only if both parties have agreed to have the dispute settled by arbitration. In the employer-employee context, the arbitration agreement is usually presented to an employee for acceptance by signature at the time of initial employment. In Gorlock v. Sports Club Company, however, the Second District faced an unusual fact pattern, where the defendant wanted to impose an arbitration agreement upon all of its existing employees. So it directed its Human Resources Director to lead a program to explain to employees and then implement the change within the company. Well, the Human Resources Director, she successfully secured signatures from 254 out of 256 employees who attended meetings. She had about another 165 employees to have meetings with. However, she never herself signed the arbitration clause, although she made statements to the CEO and other execs which gave them the impression that she had signed the clause. About 3 months into the process, she resigned, and then sued her former employer for wrongful termination, retaliation, paramour sexual harassment, intentional infliction of emotional distress, defamation, breach of contract, and negligence. The company tried to invoke the arbitration clause, arguing estoppel and an implied-in-fact contract on the theory that she had stayed with the company for 3 or 4 months, knowing that the company intended all employees to sign. Well, the Second District rejected the company's arguments. On the estoppel claim, the company could not show any detrimental reliance on her representation, since the evidence showed the company was still rolling out the program and had not even decided what to do about employees who refused to sign. As for the implied-in-fact contract theory, it failed because it was perfectly clear that she intended not to sign the agreement, and that an implied-in-fact contract comes into existence only if the conduct of the parties makes it reasonable to infer that both parties intended to be bound. On the facts in this case, that inference simply was not possible, given her clear intention not to sign and then to resign. Next, we turn to railroads. Regulation on the railroads was one of the earliest fields of commerce and law, where the federal government essentially displaced all state regulation. Because of the obvious interstate character of rail transport, Congress realized that it needed to establish one regulatory structure, and that giving states regulatory control would lead to chaos with inconsistent regulations and a more expensive rail system. The preemptive scope of federal regulations regarding the length of time a stopped railroad train may block public grade crossings was the issue before the Second District in People v. Burlington Northern Santa Fe, where a railroad, believe it or not, was convicted of a misdemeanor for violating regulations promulgated by California's Public Utilities Commission. Well, the Second District reversed the conviction. I don't know who prosecuted it, maybe an assistant DA who got stuck waiting for a train. The Second District held that either the Federal Interstate Commerce Commission Termination Act or the Federal Railroad Safety Act preempted state law with regard to this issue. So the next time you find yourself stuck waiting for a stopped train to get moving, send your email complaints to the federal government, not to California's Public Utilities Commission. Finally, we're back in the area of anti-SLAPP motions. Now, as I explained a few weeks ago, about 20 years ago, we saw in California a rise in defamation actions that were brought in retaliation for the defendant's public participation in matters of public interest. To weed out these lawsuits, the legislature enacted a statute known as the anti-SLAPP law, which creates a special process for early evaluation of the likely merits of the plaintiff's case. The acronym SLAPP means Strategic Lawsuit Against Public Participation. To trigger the anti-SLAPP law, the defendant must show that the plaintiff's complaint arises from the defendant's exercise of his or her constitutional rights of free speech in connection with a public issue. If that test is met, then the plaintiff must establish a probability that his or her claim will be successful on the merits. Now, as I said a few weeks ago, I think the courts have given an overly expansive interpretation of the anti-SLAPP statute. Well, yesterday we finally got an opinion that recognized a limit on the statute, and an important one at that. The plaintiff in this case was a doctor who was subject to a summary suspension and termination of his staff privileges at a hospital regulated by a public hospital district. He brought a petition for administrative mandamus against the hospital board, seeking to challenge the suspension and termination. The board responded with an anti-SLAPP motion, contending that his judicial action was in retaliation for their decision to suspend and terminate his privileges. Well, in Young v. Tri-City Healthcare District, the 4th District held that the anti-SLAPP statute did not apply, because the petition for administrative mandamus did not arise out of the board's exercise of any First Amendment rights. As the court explained, even though the petition was triggered by the board's activity, some of it protected activity, the claims did not arise from First Amendment protected activity. Instead, the petition was principally seeking judicial relief from an administrative body's decision. And the court made it clear that it did not want the anti-SLAPP statute to impose an undue burden on somebody seeking judicial review of an administrative agency's decision. Good decision by the court here. And that's it for today's Kelso Report. Have a great day in the law.